What is the legal eviction process? The first step in the legal eviction process is for a landlord to give the tenant a written notice to terminate the lease or a written notice to vacate. If you have a written lease, it would be a notice to terminate the lease. If you don't have a written lease, it would be a notice to vacate, probably a 15-day notice or a 30-day notice. That first notice comes from the landlord, usually in the mail, sometimes posted on the door. It's not filed in court, it doesn't come from the court. But the landlord has to give the tenant that written notice to move out by a certain date. If the tenant doesn't move out by the date in that notice, the landlord has to file an eviction case in court. Only a judge can order a tenant evicted, and only the sheriff can enforce an eviction order from the court. It's not appropriate, it's not legal for a landlord to come and change the tenant's locks to lock the tenant out, or to come and remove the tenant's belongings from the property, or to shut off the utilities. It is specifically illegal for the landlord to do any of those things to try to get the tenant out without going through the legal eviction process. If your landlord does one of those things, if your landlord locks you out, turns off your utilities, removes all of your things out of the property, the law allows you to sue your landlord for compensation. But first, you may need to take action to get back into the property if you've been locked out. If you've been locked out at the home that you rent, the first thing you should do is call the police. The police, in Duval County at least, will usually help and will come out to the property and will inform the landlord that what they've done is not legal, and they will inform you of your right, which is to get back in the property just about any way you can. You need to be very careful with this, and it's very smart to have a police officer at the property when you're going to get back in. If you've been locked out and you're going to get back into the property, it's best to have a police officer there so you won't be accused of breaking in or doing something illegal. But you do have the right to get back in unless or until you've been evicted through the legal procedure in court. If your landlord violates this law by taking some kind of action to evict you outside of court, turning off your utilities or locking you out, you may sue your landlord for either 3 months worth of rent or for your actual damages, whichever is greater. And you would most likely sue your landlord in small claims court if the amount that you're seeking is $5,000 or less. If you're suing for $5,000 or less, you would file in small claims court. And there's information about small claims court available from our office and also at the courthouse.